What evidence do you need to win your Georgia Social Security disability claim? I'm Jonathan Ginsberg, and I'm a Social Security disability attorney here in Georgia. I try cases in all of the Georgia offices of hearing operations throughout the state. And if I can be of assistance to you, please reach out to me. Now, today I'd like to talk to you about evidence, because if you think about it, when you're applying for a Social Security disability, you're in a type of court, and the court is going to look at evidence to determine whether or not you're disabled or not. You can't walk in there and say, "Judge, I know I'm disabled. Anybody can look at me and say I'm disabled. Please approve me." Instead, judges are going to rely on evidence and evidence alone to make a decision. I'd like to say that in many cases, whether or not you win or lose is about 85% the evidence in your file. It's maybe about 10% of based on your testimony, and about 5% what your lawyer does. So it's really much focused on evidence. If you can put your effort into making sure that you've got good evidence, your chances at winning go way up. So what are the types of evidence that really move the meter for Social Security? Well, first and foremost, you want to have as much objective medical evidence as you possibly can. And by objective medical evidence, I mean things like MRI reports, CT scans, ultrasound reports, cardiac function reports, breathing tests, anything that documents what's going on with you objectively, where a doctor or a judge for that matter can look at it and say, you know, this person is complaining of chest pains and his heart function is at 35%. It makes sense that this person would have chest pain, or this person has a herniated disc with nerve root impingement in L5-S1 in his spine, and he's complaining of radiating pain into his left leg. That makes sense. But if you go in and you have very mild objective evidence, meaning that you've got a small disc bulge at L3 and 4, but you're complaining that your leg is completely numb, judge is going to say, you know, it doesn't really make a lot of sense. And again, there are some cases where objective evidence and the symptoms you experience are a little bit out of sync, but generally speaking, judges know what type of symptoms are going to typically arise from these various abnormal lab tests or objective evidence type of tests. So the more testing you've got, and recent testing that's consistent with what you're talking about in terms of your symptoms, the better off you're going to be. And again, a good attorney is going to look at your record and say, you know, this is what the record suggests. What are your symptoms? And if you talk about symptoms that are really way out of proportion, the attorney's going to say, hold on, let's wait, let's take a look at this and see, does this really make a lot of sense? Because again, if you testify that you're having excruciating, 10 out of 10 level pain down into your legs, and you've got nothing in your back other than a mild disc bulge, that's going to really suggest that maybe you're not entirely credible, not entirely believable. So I'd much rather have somebody that talks about symptoms that are consistent with their objective testing and try to build a case based on multiple medical problems and the symptoms that arise therefrom, as opposed to putting everything into a particular symptom or set of symptoms that's not consistent with your medical diagnosis. Number two, I think medications are really important in disability cases, and you need to know, by the way, before your hearing and even throughout the case, what your medications are, what the dosages are, and what the side effects you're experiencing. Because in some ways, the medications are kind of a cliff notes to your underlying disabling condition. If you are complaining again of back pain, let's say, or knee pain, and your doctor has you on tramadol or non-prescription Motrin, you know, that's not really that consistent with the level of pain you're complaining about. But if you're on Tylenol number 3, if you're on methadone or morphine derivative or OxyContin, and you've got a certain level of pain that is severe, but this medication is designed to deal with it, you're on Percocet, then that's consistent. So I think that having medications that are consistent with your allegations of pain or your symptoms that you're experiencing, that goes a long way to showing that you're believable and credible. So that is evidence that can make a real difference in your case. Number 3 is if the doctor in your case has suggested that surgery is necessary, that suggests you've got a serious problem. And now realize you don't have to actually have the surgery, and Social Security judges will not punish you or deny you because you've decided not to have an invasive surgery, although you should have thought about and discussed with your attorney how you explain why you decided not to have surgery. Maybe it's the potential side effects. Maybe the likelihood you would not get relief from your symptoms. You need to have a reason. But if surgery is suggested, that's pretty serious. And again, that's consistent with a pretty severe medical problem. And of course, if you have the surgery, that's not always successful, or you have extended recovery or infections or complications, that can play into this as well. But anytime I see surgery in medical notes, that says to me, I've got something very serious. If you have a mental health condition, this would be number 4 in terms of the factors I think that are important with evidence. If you have a mental health condition, what judges are going to be looking for are things like inpatient psychiatric hospitalizations. They're going to be looking for suicide attempts. They're going to be looking for recommendations for ECT or electroshock therapy. They're going to be looking for evidence that the doctors tried multiple medications, none of them have worked. Evidence that your behavior at times is completely non-functional. You couldn't function at home, you wouldn't be able to function at work. It's a really, really high level. Now, I want to make it clear. If you're going for disability based purely on a mental health condition, that's the level of mental health problem you got to have. But you can also use mental health issues as part of the puzzle. And what you can do is you can say, well, I'm not totally disabled by depression or bipolar disorder, but what that may do is it may eliminate jobs that require complex calculations or complex instructions or interacting with coworkers and supervisors. In other words, you can get rid of entire classes of jobs and whole swaths of jobs based on mental health limitations. So again, you never want to exaggerate, but if you've got a mental health issue that is not inherently disabling on its own, but is part of the puzzle, we can certainly talk about that, and that's again something I would discuss with my client, but that can be part of the picture, and that's just fine. So it's okay to have a milder level of mental health problem, or any problem for that matter, if it's part of the puzzle and part of the pieces of your argument for disability, that when you combine all these things together, the cumulative effect of the mental health problem, the back problem, the knee problem, the heart problem, the foot problem, when you put them all together, there are no jobs that would allow somebody with all these conditions to function. But again, if you're purely basing your claim for disability on mental health, it's got to be at a really, really severe level. Otherwise, the judge is going to say it's mild enough where you could get through working a complete day in a simple entry-level type of unskilled type of job. And the 5th thing I would tell you about evidence is that, and I'm using this a lot now, is what I would call non-medical evidence, and that is letters from former coworkers or supervisors or even customers, or sometimes from friends or relatives that describe the issues you're dealing with. Someone who's known you for a long time that can describe the deterioration of your functioning. And in fact, I had a case recently where I contacted my client's former boss. He'd worked for the same agency. It was a government agency for over 20 years. I talked to the boss, and he was like, yeah, absolutely. This fellow was a really good worker, but about 6 or 8 months before he stopped, he got hurt in an accident outside of work. It wasn't a workers' comp case. And after that, he couldn't do his job. And we had to cover for him. We had to make excuses and give him some extra breaks. And over time, it just got worse and worse. Well, that's exactly what I need to know, because I go in front of the judge. I can say, look, this gentleman was working. He was doing a good job. He got hurt, and things just kept getting worse and worse and worse until finally he got to the point he simply could not do it all. And the former employer's statement really is a piece of that puzzle, and it's really compelling evidence, because this fellow doesn't have any reason to lie, doesn't have reason to not tell the complete truth. It turns out he's actually a government official that would be trustworthy just on his own, and I think it's a very, very helpful bit of information. So if you can get former coworkers, supervisors, people that know you to talk about some of the medical issues and the deterioration of your function, that can be very, very compelling and important evidence in your disability case. So that's kind of my summary about the types of evidence that I look for in a disability case. If I can be of help to you, please reach out to me. Again, I practice in all hearing offices throughout the state of Georgia. You can reach me at 770-393-4985 or by email using the form on this webpage, or my direct email is Ginsberg, Ginsberg, @gmail.com. Look forward to hearing from you soon. Thanks a lot.